Right. Hey, everyone, and welcome to Ethics Jeopardy. Thank you all for tuning in for your daily dose of Jeopardy, brought to you by the Dallas Young Lawyers Association in partnership with the litigation section of the State Bar of Texas. As a reminder, watching the CLE will give you 1 hour of CLE ethics credit, which will need to be self-reported through the State Bar of Texas. The CLE number is 174-116689. Now entering our virtual studio, today's guests and host that will be presenting and fielding your answers. Cade Browning, owner of Browning Law Firm in Abilene, Texas. He serves as chair-elect for the litigation section of the State Bar of Texas. Joining Cade is Rebecca Vela, the owner of Rebecca Vela PC, a litigation firm in Edinburgh, Texas, and is the membership chair of the litigation section of the State Bar of Texas. We are also joined by the Honorable Judge Xavier Rodriguez of the United States District Court for the Western District of Texas, who is the current president of the litigation section of the State Bar of Texas. The members of the Dallas Young Lawyers Association will compete on today's Ethics Jeopardy for a variety of prizes. Now I'll throw it over to Judge Rodriguez for further discussion on the litigation section and to get us started. Thanks, guys.
Thank you, Kaylee. And thank you all for joining us today. Hopefully we can have some fun here with Ethics Jeopardy. Again, I'm the chair of the State Bar of Texas litigation section. And on behalf of the 9,000 members strong, we're welcoming you, hoping you will enjoy this program, get a little taste of what the litigation section does as we try to empower advocates, promote the rule of law. And we do this primarily through a lot of education efforts. And so this is just one of many presentations we give. And so as you all advance through your careers, we hope you think of us as a resource to assist you as you navigate your litigation career. So with that, I'm going to turn it over to Kate and Rebecca. I'm going to monitor the winners and let's have some fun.
Thanks, Judge. How is everybody? My name's Cade, and welcome to beautiful Buffalo Gap. And we're here today to do the Ethics Jeopardy. And so what we're going to try to do, I'm going to share the screen here, and we are going to do a PowerPoint presentation. Rebecca, can y'all see that?
Yes.
All right. So the way this is going to work, we're doing it via Zoom. And so we're going to have questions and answers on ethical questions. And so the way to answer these, since this is via webcast, what we're going to do is we're going to ask the question. And then if you know the answer, and even if you think you know the answer, or even if you think you might know the answer, but there might be a small chance, what you do then is respond in the chat section. And Judge Rodriguez is going to be monitoring that, so please don't disparage the federal judiciary in this context. But then he's going to be collecting those winners for each and every question. There's probably, I don't know, Rebecca, what is there, 20-something questions?
More or less, yes.
And as he goes through those, then at the end, if you were a winner chicken dinner, we're going to send you the award. And so for each of these different questions, there's going to be a gift card. And listen, these gift cards, this is the real deal Holyfield, because it's got an Amazon gift card, a Chick-fil-A gift card, a Starbucks gift card, and most importantly, a Whataburger gift card. So now here's the deal though. Some of you folks might be super fast typers or what you called gunners back in law school. And so we don't want you getting every $10 gift card. So answer one, if you win it, give it a spell for a little while before you answer again. So Rebecca and myself and the other fellow in the middle is Raymond Beza. Raymond's from El Paso, and he is our TYLA representative to the Counsel of the Litigation Section. He's unable to be here today, but thank him and the Dallas Young Lawyers for setting this up today. So without further ado, let's get started on some ethics. This first one is a Starbucks gift card, Ethics 101 for $100. Question: who issues the Texas Legal Ethics Opinions? If you know the answer, type it into your chat. You can search these online. It's a great way to do it. They have a great search engine that you can do natural language searches on. There's also, if you're a Texas lawyer, you have to be a Texas lawyer, which I assume all of you people are. If you are, you can also ask for an opinion on an ethical conundrum. So have you all answered your chat? The answer is the Texas Committee on Professional Ethics. Now, this committee is a 9-person committee appointed by the Supreme Court of Texas, and they answer these ethical issues. There's hundreds and hundreds of them on there, and we'll be talking about a lot of them throughout the process today. Rebecca, take it away.
Next up is advertising for 100, or in this case, a $10 Amazon gift card. All advertisements in public media for a lawyer or a law firm must first be reviewed and approved in writing by whom? So if you're advertising anywhere out there in public media, albeit in written form, on social media or any other format, television, who has to approve that, that advertising in writing? Please type your guesses in the chat. And again, the winner for this will receive an Amazon gift card. The answer to this is the lawyer or the law firm. Now that's Texas Disciplinary Rule 7.04 subsection 3. So there is a state bar advertising committee that does have to review some of this advertising, but in fact, before it goes up there, we ourselves are going to police what we're advertising, send that up to review to the committee that will review and finally approve any advertising that you're putting out there in writing.
So guys, you know, I am monitoring both the chat and the question and answer. But if you can write in your answers in the chat. But so far we're stumping the group, guys.
Stumping the group. They must have better ethics than that. Judge, don't take down names. Potluck for $100. Attorney-client communications must always be what before they can be considered privileged? Now, this is for the Monterey Melt or the green chili burger, depending on your geographic location. The attorney-client communications must always be what before they're considered privileged? Is that the song? What must those communications be in order to assert that privilege that nobody could ever ask about? All right. The answer must be confidential, of course. So this comes up all the time. Listen, I'm a trial lawyer here in Abilene, and I do personal injury trial law from the plaintiff side 95% of the time. So folks come in and they want to bring their brother-in-law or their sister-in-law or their grandmama or their preacher or somebody into the room. And so and the criminal defendant attorneys also have to worry about this sometimes. And so does that breach confidentiality if they're in there? And so the safest thing to do is just know that it's going to have to be confidential. If you can't talk to somebody and have the dog catcher walking by and hearing it all and you knew about it and still try to claim confidentiality. So there's that one. So Whataburger for $10, confidential.
I think we had a winner for that one.
We did have a winner. We had Angelica Farinacci. Congrats.
The Monterey Melt is a fine sandwich. Fine.
So if you all would answer in the chat, that's what Judge Rodriguez is monitoring. If there are any questions that come up during our presentation, I think we forgot to mention, but you're welcome to type that into the Q&A portion. And if we get a chance we'll stop and answer those questions. Otherwise, perhaps we'll answer them at the end of this presentation if we have time. The next step, for a Chick-fil-A gift card, can a lawyer accept a payment for services from a source other than the client? Meaning, you know, maybe from a parent, mom or dad, from a spouse, friend, cousin. Please type your answers in the chat.
Well, most everybody wants any type of payment from anybody.
Well, that might be true, okay? That at the end of the day, we want to make sure that we get paid for our services. But the answer is that the client is yes, but the client must consent to the arrangement after consultation. And there must be, and this is important, there must be no interference with the lawyer's independence of professional judgment and information relating to the representation of the client. And of course, as we saw in the last one, any communications and the representation must be kept confidential. So just because parents are paying the retainer fee or paying for your services doesn't mean that they get to call you and ask you what's going on in their adult child's case, or they can sit in on every meeting that is discussion of strategy, or how you're going to proceed forward, because that then you'd have an issue with confidentiality and your attorney-client privilege.
All right, we're good. Oh, sorry, Rebecca. I think you're going to do this polling question, aren't you?
That's right. So we have the first polling question. And we'd also, for this, we'd like y'all to type your answer in the chat. Oh no, there's the polls up there for you. So the first question is, are you a member of the State Bar of Texas litigation section? You can answer yes, no, or what the heck is the litigation section? I've never heard of it before. So if we'll give you all a minute to answer that, and then we'll move on to our next Jeopardy question.
All right, civil and criminal for 100. What must defense counsel, here's your tripartite relationship question. What must defense counsel do if an insurance carrier refuses to authorize retention of a necessary expert? You got that? So your insurance defense lawyer, you've been hired by the insurance company. Of course, you represent the client, and there's an expert that needs to be done. But the insurance company says, that's fine and dandy, guys, but I ain't writing a check. So what do you do if you're the insurance defense lawyer in this situation? Answer those chat questions.
That's a pickle.
It can be a pickle. It can be a pickle. All right. Here's the answer. I think if I can get this to work, there it goes. Hire the expert anyways. So a little dangerous territory there, but there's a employers casualty company versus Tilley is a 1973 Supreme Court case. Y'all probably remember saying we have an unqualified duty of loyalty to our clients. So when that happens, and here's back on those ethical opinions that you can search, there is an opinion right on point. It's opinion 533. And what it says that the lawyer shall not accept compensation for representing the client from one other than the client unless there's no interference with the lawyer's independent professional judgment with the attorney-client relationship. So in other words, it's impermissible under the rules for a lawyer to agree with an insurance company to restrictions which interfere with the lawyer's exercise of his or her independent professional judgment in rendering such legal services to the insured, your client. So there you go, little tripartite relationship fun.
All right, next up is for a Chick-fil-A gift card. And the question is, an attorney who participates in written solicitation pursuant to the advertising rules must retain the documentation for how long? So if you're sending out a letter, an advertising letter, and I'm sure we've all seen it, typically you see these in the criminal law context, but I've seen some even in written solicitations when big storms come out and you see something, you receive something, and then you're sending out something in the mail. How long do you have to keep that written solicitation for?
I've seen it in car wrecks too.
Type your guesses in the chat. What do y'all think? The answer to this is you've got to retain it for 4 years, and that's in accordance with the Texas Disciplinary Rule 7.05 subsection D. So make sure that you retain all of those written solicitations for the 4-year requisite time period.
All right, money for 200. Starbucks gift card. The disciplinary rules permit an oral fee agreement between a lawyer and a client. With what exception? What's the exception to you and I cutting a deal verbally about our fee arrangement? The tune is off, I think.
Yeah, Everyone should know this one.
I can't remember the team.
We've been stumping them lately, guys.
I know.
Oh, come on. Y'all know this one. What is the only type of case that you can't have a oral fee agreement? The answer, 3, 2, 1, contingent fee agreements.
There you go.
My stuff, the access to justice for those that don't have any other way. And Texas Rule 1.04 specifically sets out contingent fee agreements shall be in writing. Now, listen, I think, it's a good idea that all fee agreements ought to be in writing ethically. And in fact, that is in the rules. If you look at 1.04C, it says when the lawyer has not regularly represented the client, the fees shall be communicated to the client, preferably in writing. So the deal is just go ahead and get it in writing. But, with the corona, this is an interesting deal because we've had, you're not meeting face to face. We do a lot of trucking litigation here. And so, for instance, had a case the other day, bad 18-wheeler wreck, and the client, got air flighted off to the hospital, and we were trying to get things going and protect the scene and protect some of the evidence. And so talking on the phone, so how do you do the contingency fee writing in writing when we're in the middle of a COVID world? Some people don't have access to be able to sign Adobe or whatever. So how do you handle that? Well, we were saying, we'd send the contractor, do it, and send an email back saying, hey, that's good, give it a go, and all that type of stuff. And so maybe that could be in writing, but there is a Texas Civil Practice and Remedies Code 82.065, which says all contingency fee agreements, it's further than the disciplinary rules, have to be writing and signed by the client and the lawyer. Not only in writing, but signed. And if it's not signed, it's voidable. You could do 5 years worth of work and it's voidable if it's not signed. And there's a caveat in there that you should have some quantum Marriott claims on some fees, but nonetheless, contingent fee agreements, writing and under the law, signed. Good deal to get them all in writing though, right?
That's the best practice.
Yeah, here's another polling question. Who pays your State Bar of Texas section dues? And some folks may be like, I don't even know what the heck is a section. That's one of the polling questions here. And of course, the State Bar has various sections. I can't even remember how many there are, Judge. You remember 20 something total?
Oh,
sections?
no, I think something like 30, 40.
30 or 40 sections. Well, the litigation section, we're 9,000 members strong, and we operate under the State Bar, but on our own too, concentrating on helping litigators and litigation issues, empowering advocates and promoting the rule of law. So it's separate and distinct, costs $30 generally to join dues. It's on your dues statements, or you can join just anytime you want, or a sustaining member. A lot of our dues also go for grants and scholarships and internships for legal services and on litigation related subjects. Sustaining member is $100. So this polling question, who pays your State Bar of Texas section dues? Is it automatically done, or do you have to do it yourself, or do you not even know what the heck I'm talking about?
All right, up next for an Amazon gift card. When can an attorney use confidential information of a client to the client's disadvantage?
Disadvantage.
That's disadvantage. So we'll give you all a little time here to answer.
Now, a lot of times my clients' non-confidential information sometimes is to their disadvantage.
That happens. I have found that myself. That's why I tell them, tell me everything, and I'll make the determination as to what's relevant and what's not, and what's important and what's not. Well, the answer to this question it has changed a little bit. It was that only when the client consents after consultation, and that's out of Rule 1.05B2. But as you all are all aware, we just had a rules vote earlier this month, and so we have 2 new rules that are in place that deal specifically with confidentiality, and were added to this section 1.05. And so the new rule clears up some ambiguity that we had, we as attorneys had. So subsection 9 indicates that we can use that confidential information to a client's disadvantage if we are seeking legal advice about the lawyer's compliance with the Texas Rules of Disciplinary Procedure. So if we're asking for an ethics opinion, basically, you can talk about that confidential information that was provided to you. The other new rule is when the lawyer has a reason to believe it is necessary to do so in order to prevent a client from dying by suicide. So if there's any confidential information that would be to their disadvantage but would ultimately harm the client, then we have the ability to disclose that information.
So I think we got close enough here with Jeremy Overby getting a correct answer. But, you know, I'm not quite certain that Michael Sheeter also doesn't have a correct answer. So he references malpractice suit. And so if the client does sue the attorney for malpractice, I'm questioning whether from a defensive standpoint in that particular posture, the attorney can disclose some material.
That's interesting.
Well, I would argue that would be you're giving consent. You're opening the door to that because of the fact that the client is suing. Therefore, you would have to reveal whatever pertinent information you obtained in the underlying suit, which might be confidential information.
Yeah, so I'm not sure it's explicit consent, but it sure is sort of implicit.
Right.
We'll have two winners on this question.
All right.
So says X-Rod Alex Trebek. All right, the next one, malpractice claims for $200, another Whataburger gift card on this one. According to an American Bar Association study, what percentage of legal malpractice claims arose from the simple failure to calendar a known deadline? So you're getting sued and it's simply you forgot to calendar the deadline. Now, this number is a little specific, so let's just do the closest two, Judge, okay? The closest two. So this is just a wild guess for most of y'all, unless you've heard this.
So this is closest to, everybody ought to be throwing a number out there.
That's exactly right. Unless you've actually read the Profile of Legal Malpractice Claims 1996 through 1999 by the American Bar Association Standing Committee on Professional Liability. Titillating reading. So that answer of just forgetting a calendar of the deadline, 7.03%. Now, I dug into this one a little deeper though, and that's the number. That's the number. But there's actually, that's fell in the calendar of the deadline. There's other numbers that are related to this, just purely identifiable administration scheduling orders. For instance, 1.27% was failure to react to the calendar date. So you got it calendared and forgot about it. Procrastination was 4.95%. Taken together, administrative scheduling errors as a total were nearly almost 13.5% or so of all legal malpractice claims. So that's something we can all work on our systems, our programs, our ticklers, things like that to have multiple layers, just to take that 13.5% and chuck it out the window.
And just as a side note to that, as I've sat on our state bar grievance committees before, and just so that you all know, even if it's an administrative error, those errors are ultimately ours. We take them on as the attorney. We're in charge and we're responsible. So even though my paralegal may be calendaring or miscalendaring a deadline, ultimately it's my error and I'm the one who's going to be held responsible for that. So it's something that we all have to stay on top of.
Buck stops with you.
Absolutely.
We had a grievance committee trial on that exact issue, and yeah, it stops with you.
So this one's going to Dameron and Barron.
All right, congratulations. What a burger.
Next up, it's our advertising. Is it permissible to include retired judge, that phrase, on the letterhead and business cards of a practicing lawyer who has retired from service as a part-time municipal court judge?
Retired judge.
Retired judge. Any guesses?
Judge, what are you going to do on your letterhead of business card? Are you retiring?
Well, the answer to this is that yes, it is permissible if the lawyer has actually retired from judicial service. And it's really, it doesn't have to be a municipal court judge. It can be a judge in any position, in any elected or appointed position, if they are truly retired. And the term retire is used in the ordinary sense of that word. And it's not likely to mislead those that are out there seeking potential help from a lawyer. And so it should be noted that there are opinions out there that address these issues related to the application of the disciplinary rules of professional conduct. And in some cases, the Code of Judicial Conduct may actually govern certain aspects of the conduct of the retired or former judge. So we're just talking about the disciplinary rules here. Now, what you cannot do, and it's very specific in our rules, is if the judge is basically a retired lawyer, no longer a lawyer, but is currently a judge and is sitting on a court, you as the law firm have to remove that judge's name. If they are a current sitting judge, they must be removed from the letterhead and business cards. They can no longer appear on either of those, because the rule is very specific that we're talking about retired judge, not current sitting judges. And I know there is also a Court of Appeals opinion out there that specifically addresses this particular issue with regards to a grievance that was filed against a lawyer who was continuing to utilize a current sitting federal judge's name on their letterhead. And the Court of Appeals held that it must be removed.
Judge Rodriguez is like, retire? I got a lifetime appointment, dog.
No need to retire.
All right, money for three. Did we have a winner on that one?
We did not.
No winners. All right, here's one. This ought to get a winner. For 300, not 300 Amazon dollars, it's still $10 Amazon, but theoretically speaking, money for $300. A lawyer may not enter into an arrangement for, charge, or collect a contingent fee for representing a party in what type of case? What type of case? That you cannot have a contingent fee. And I'm going to call it. And the answer is criminal case. Rule 1.04E, a lawyer shall not enter into an arrangement for, charge, or collect a contingent fee for representing a defendant in a criminal case. I'll mention there's an interesting ethics opinion, though. So what about court appointment fee schedules? Because they're different on the different ranges of felonies or misdemeanors or whatnot, right? So is it contingent upon you get paid more if it's indicted on something? So are those county fee schedules, or even fee schedules where you charge differently on the degree of the criminal statute or the punishment? And it's opinion number 636 that said those type of contingencies are not contingent upon a successful outcome for the client. So they are permissible. And it says the committees of the opinion that an agreement for payment of one amount of the case is, if the case is disposed of without trial, or a larger amount if it proceeds to trial, is not contingent, but merely an attempt to relate the fee to the time and service involved. Also, since we're talking the Dallas young lawyers here, there's an interesting recent order from the 68th District Court in Dallas that a lawyer, like a personal injury lawyer, cannot enforce a lien against a client's criminal restitution recovery. You know, sometimes the victims may get a criminal restitution, and the attorneys, I thought that was just interesting when I was researching this, that, yeah, you can't go in and say, I want my 30-year criminal restitution as part of your lien. So there you go.
So we got a winner on that one. We got Madeline Wells. Guys,
job.
if you could help me out, I appreciate it, because it's kind of hard to bounce back between the Q&A and the chat to see who came in first. So if you could use the chat, that would be helpful. But Madeline Wells got that one.
Congratulations, Madeline.
All right, next up for a Chick-fil-A gift card. Is it against the rules to pay a referral fee to a disbarred lawyer? Now, I will say that this question created some discussion amongst us. So let's see what your opinion is.
So this is the disbarred lawyer referred you the case.
That's correct.
Did he refer it before he was disbarred or after he was disbarred?
Well, he can't refer a case.
I guess that's right.
He can't refer a case after he's been disbarred. And then that answer would be obviously no, because there's no referral fee because he would be a non-lawyer. So the answer to this question is it depends. So it'll depend on whether or not the work that was contemplated under the contingency fee contract was completed prior to the suspension or disbarment, as well as whether this case has funded or settled, resolved before the suspension or disbarment. So if you have a lawyer that has referred a case to you, the case is ongoing. During that pendency of the referral, the lawyer is suspended. You continue on with your case, and then the case settles before the suspension is lifted, before or while the lawyer is disbarred, then there is no referral fee that would be paid to that disbarred lawyer. However, if that suspension or disbarment took place and the case was fully resolved, but maybe it hadn't funded at the time, well, then those fees can be paid. A distinction to this is that if that attorney has invested funds in the workup of the case, for example, in a personal injury case, perhaps they gave a medical advance to one of the doctors in order to help with treatment, and so it lowered the medical bills on behalf of the client, or it was paid on behalf of the client. Those expenses can be reimbursed to a disbarred or suspended lawyer, but we're looking specifically at attorney's fees from a contingency fee contract. And as everyone knows, we cannot pay fees to someone who is to a non-lawyer, and in this case, it would be a non-lawyer. So you've got to look carefully at the situation that you're involved in.
And I assume that's, of course, contingent upon the referral rules too, joint representation.
Absolutely. And it would be contingent upon this as well. One of the caveats that I didn't mention is, let's say, for example, the case had been completed but not funded prior to the disbarment of this lawyer. But the basis for the disbarment of the lawyer was whatever malfeasance within that case. Perhaps it was a barratry disbarment, and the claim was that the attorney committed barratry in obtaining that contingency fee contract. Well, in that case, even though all work was completed and the case was settled prior to the disbarment, then there would be no funds, no attorney's fees that would be paid to that disbarred lawyer, because it was the basis of the disbarment.
So since the answer, Rebecca, is it depends, does that mean the winner, it both says yes and those that said no?
Probably is.
It's a trick one.
That was rough on the crowd.
I think that the gut reaction to that is no, which is what our discussions were prior to this. When we were preparing for this, the answer automatically is to say no. And you just need to be aware that there are certain situations where there would be some payment. And if you're dealing with a situation where you are the attorney that the case was referred to, the referral attorney is now disbarred or is suspended, then it's probably a good idea to shore up a contract yourself directly with that client if they're willing to do so, because of the fact that you are going to be in limbo over this contingency fee contract issue. You just need to keep in mind that if you have been working under certain terms of your contingency fee contract, you can't then change them to your advantage when you're renegotiating that, or try to renegotiate that contract. Then you can open up a whole other can of worms.
That's interesting. That's good advice. I've had this come up a number of times, so that's good to know. Thank you. Okay. Malpractice claims for $200. Is it against the rules to threaten criminal, this is a typo on here. Is it against the rules to threaten criminal prosecution in a civil case? That's supposed to say civil case. Is it against the rules to threaten criminal prosecution in a civil case? Yes or no? Yes or no? And this happens, you know, in our practice, it happens sometimes because you have an involuntary manslaughter charge on a truck driver or something. It also happens in a lot of our rural counties where the DAs do a lot of theft of service prosecutions that also could be debt collection cases. So that comes up. I guess it could come up in other family law, those type of things. So the answer is yes. It is against the rules to threaten criminal prosecution. But there's a layer in here. 4.04 of the rules say, B specifically, a lawyer shall not present, participate, or threaten to present criminal or disciplinary charges solely to gain an advantage in a civil matter. Did you hear that word? Solely. So solely, can't threaten it solely to gain advantage. So that leaves a little bit of oomph in there, right? There's an ethical opinion out I read on this, opinion number 455, which is very similar to what. So we have an involuntary manslaughter case on a 18-wheeler driver that killed somebody, and so we had this come up not too long ago in a case where the DA was looking at indicting the fellow for it, and he was asking us for information and help on it. And what this was a similar type situation where the plaintiff, the victim, wanted to press charges and asked their lawyer to liaise on that with the district attorney's office. And what the opinion 455 says is you can't do that solely as the attorney. Now, the victim can obviously pursue the prosecution for their own purposes, but it was just that solely language is there to distinguish some of that help that you may have to give. But at the same time, that's a slippery slope, I think. And so best just steer clear of that, in my opinion. But that's the rule, 4.04 and opinion 455.
So Jeremy Overbay is going to Starbucks.
There you go, Jeremy. Was he taking a second trip to Starbucks? All right, now listen, this is what Judge Rodriguez had mentioned at the beginning. What does a section do? Well, there are however many sections, 30, whatever, they all do different type of things, right? What we do as a litigation section is try to help our practices be better and to also educate the public. And some of the ways we do that are some of the different benefits available to you as a member. We were talking before the call. I came from the young lawyer world, president of our young lawyer here in TYLA board, and Rebecca was the same. And we had kind of had this talk earlier with Callie as well, that we thought, you know, the litigation section is something for older lawyers. Like you graduate from the young lawyers and get into the old lawyers. And I'm going to tell you, that's just not the case. It is open to everybody. We have a law student division, and there's lots of things in there that we do that can help your practice and hopefully make your practice better. And so some of those we could talk about, and we will here in just a little while. But this polling question is, what benefits would entice you to become a member of the section, if you are now or not? Free CLE, networking opportunities, legislative news. God knows we got a lot of that going on right now. Access to timely litigation section publications. As a member, if some of y'all are a member, you know, you get the quarterly Advocate, which is a hard copy symposium that's really top rated, current issues going on with our practice, and they are a great resource. And we also have a News for the Bar with kind of less substantive but very useful articles in there for research as well. And then obviously also grants, internships, and scholarships that we provide for legal internships to legal services related to litigation, and grants for nonprofits that need help to help promote justice in our state, and scholarships for folks to attend some of our CLEs. So if you could answer that poll question, that would be much appreciated. Thank you.
All right, next up, Malpractice claims. What is the statute of limitations for a legal malpractice case?
3 days.
No such thing. And you know, I guess all of these are coming to me because our answer again to this one is it depends. So it depends because your basic negligence and DTPA actions are subject to your 2-year statute of limitations, beginning with the date of discovery. And if the basis for the malpractice is for fraud or breach of fiduciary duty, you're subject to a 4-year statute of limitations, also running from the date of discovery. So the discovery rule applies in malpractice claims just like they would in any of your other claims that you're handling on behalf of the client. It would be when the client discovered the legal malpractice.
So I think you should give a gift card for anybody that said 2 years and anybody that said 4 years.
And so we're giving it to Jennifer Davidson.
All right.
All right, Jennifer. Did she say 2 years and 4 years, or did she?
No, she said 2.
All right. Well, that's a winner.
Everybody's hoping for 2. Unfortunately, it's not 3 days like
Cade was hoping for.
All right. And again, malpractice claims. Do the rules.
Kate, I'm sorry. I'm going to jump in there. We're having some issues on the back end of people saying that they are not getting their answers correctly in the chat. I'm not sure what's going on here, and I'm not sure how to remedy that. I just want to address that and apologize. I know that we've had some people reach out and say that they've sent in the chat and they've sent screenshots, and I'm not seeing it on my side, and so I'm sure that y'all are not seeing it on your side either. So
if the chat's not working, let's go to the Q&A.
Yeah, it is. If people have had trouble in the past answering in the chat, try the Q&A and we can try that way.
I'm actually keeping all the Whataburger gift cards.
All right, sorry.
It's a ploy. It's a ploy by Cade.
Yeah, sorry.
We don't have a Starbucks in Buffalo Gap, but I can get to a Whataburger.
All right. Well, let's hope that this fixes it, and we can continue this Jeopardy. I'll turn it back over to you, Alan Trebek. Oh, I mean, Kate. I'm sorry.
Thank you. Sorry about that, guys. Part of the Zoom. Listen, we hope that this is all over and we're doing these in person. And the way we've done them in person before is instead of Whataburger, we're buying drink tickets at a happy hour. And that's a hell of a lot more fun. But we're going to do the best we can. So the question now is this, my friends. And so do the rules require a Texas lawyer to report to the appropriate disciplinary authority another Texas lawyer's use of a trade name that is based on the name of the city where the second lawyer practices? The Buffalo Gap. Palladium of widows and orphans. Now this is, do the rules require you to report somebody's use of a trade name? Yes or no? So the answer is no, unless a lawyer who considered making such a report concluded the particular circumstances was a substantial question. Now, see my asterisk on there? Because here's the deal, and Rebecca mentioned it earlier. Last week, the referendum came down, right? March 4th was the final results. And one of those was totally redoing chapter 7, and it whittled it down from 7.01 to 7.04, I think. And it totally changed a lot of these advertising type things. And one of the issues applicable to this question is trade names. And so it passed. It passed on the lowest level of all the other ones. It passed with 78.93% of the vote. And what it says now is lawyers may practice law under a trade name that is not false or misleading. So as long as it's not false or misleading. Now, a lot of us didn't necessarily like that, but listen, we have something called the First Amendment, and we were going to end up having that litigated at some point. The bar does the restriction on trade names violate the First Amendment? So welcome to the wonderful world of trade names now. However, still with the caveat.
We're going to give this to two folks. Zachary Herbert came up with a correct response, but so did a great trade name, Captain Awesome. So Captain Awesome
hope he hadn't
also came up
copyrighted
with a law student answer with yes, but there's a caveat. We're given 2 awards here.
That sounds like a good plan to me. It'll be interesting to see what this looks like. I think it'll be interesting to see what happens in some of the other. Now, there's a lot of specifics. I encourage you to go read the advertising thing, because it really did change a lot, right? On how these things are, how they're done. Anyhow, okay, let's move on.
Next, our potluck. When a lawyer is retained by a company or an organization, who does the lawyer represent? All right. And the answer to this one is the entity, so the company or the organization. And unless your engagement letter says otherwise. So sometimes in business litigation, we'll find that the company gets sued and one of the employees is also sued. You as a lawyer would answer on behalf of whomever it indicates in your engagement letter. That might be the company, that might be just the employee, or it might be both. But typically under those circumstances, you are reporting to the company, to the organization itself, not to the individuals within the company. And that's who you represent. That's who the best interest is that you're looking after.
So we had a lot of people chime in correctly on this one, but Blair Bennett got in first.
Well, I'm glad we got this question answer thing. Now everybody's cooking, baby. Thought everybody was just eating their Chick-fil-A and not typing. All right, money for $400. Well, theoretically. Amazon for $10. If a fee is paid in advance of representation, can a lawyer take that money for his or her own use? If a fee is paid in advance of representation, here's a bunch of money, go represent me. Can a lawyer take that money, put it in their pocket instead of in their trust account? And the answer is no. Advance fees are not earned and they go into the client's trust account. However, again, like Rebecca was just saying, your fee agreements in writing need to set this out a lot. And a lawyer can collect what's called a non-refundable retainer, obviously, or a flat fee and receive the money personally without putting it in. But if some of those monies are contingent upon something that happens in the future, like, hey, here's X amount to represent me here, and here's another X amount in case we go to trial, the advance fees must be kept separate. Rule 1.14, safekeeping of property. Remember that? So you put those in there in the trust account if it's for advance fees. Now, the rules have an interesting comment about non-refundable retainers, I thought. Obviously, the advice is make it very specific in your fee agreements. But what the rule said is it's non-refundable retainers are not inherently unethical, but must be utilized with caution. And that's what the opinions I've got on there indicate. So they sound like they're kind of frowned upon a little.
A lot of people chimed in on this one correctly as well. There is, I think, a fluke in the system because I initially saw Nicole Plagan's name come up first, and then there was a blip on the screen and Dameron Barron popped in as answering before. We're giving it to both.
Is this election fraud? Are you telling us there's voter fraud here?
It's the Russians hacking into this system.
No, but I think it's starting to work better now in the Q&A. So I appreciate the switch and everyone, and thank you for all the participation.
Those federal judges, they ride herd on these elections. It's just the way, the way it goes. All right.
All right, next up. And this one we should have a lot of answers. A member of the Texas Bar shall complete how many hours of continuing legal education during each reporting period?
Oh, I'd be Googling that if I had a keyboard. Google that up.
And the answer to this is 15 hours. Now, this is something that we should all be aware of, how many hours we need to complete. And a portion of those hours must be completed in ethics. And so fortunately, you'll get 1 hour of ethics here for your completion of this CLE today. And an interesting thing for you all to also remember is that, you know, some of these ethics hours are the hardest to come by. You can do self-reporting as well. You can self-report for 1 hour. So if you're doing your own, reading your own opinions, reading some of these, for example, reading the advocate that the litigation section puts out that has all of this relevant information on current case law, current status, and what everyone is doing. If you're reading that, you can self-report for up to 1 hour, including ethics in that.
So a lot of people chimed in here. It went to Joseph Schulke.
Rebecca, you want to handle this polling question?
Sure. So our next polling question is, Kate talked a little bit about some of the benefits that the litigation section offers. And so for those of you that are not members, or even for those of you that are members of the litigation section, what would you like to see the litigation section, the State Bar litigation section offer in order for you to spend your money or your firm's money to join this section? So if you would type in, I'm assuming we'll probably need to use the Q&A because—
So Callie's telling us it's going to have to be in the chat to be captured, I believe.
So I don't think we have the chat turned off, but what we can do is go ahead and answer in the Q&A, and I can do it on my end. So let's answer in the Q&A, and I can do it on my end.
Okay.
It's just the Jerry Maguire question. What can we do to help us help you? Oh, you're up again.
All right. Next up, under the Texas disciplinary rules, is a delay for delay's sake a permissible litigation strategy for a lawyer?
That sounds like a Corona question.
Yeah, I was just going to mention we've had a lot of delays over this past year. I can't exactly say that the delays were simply for delay's sake, but you know, some lawyers may have done that and used Corona and the court delays to their advantage in this situation. But the answer to this is no. And if we look at Texas Disciplinary Rule 3.02, it clearly sets out that we cannot use a delay just for the sake of delay. And if you look back and if you think about it, anytime you're filing a motion for continuance of a trial setting, it is required that we verify those requests for continuances. And part of that verification is that you are not seeking a delay in the case simply for delay's sake, and it's not going to be to somebody's disadvantage. There is a particular purpose for the delay, but it cannot be for delay's sake. So not only is it a disciplinary rule, but it's a requirement in most of our motions for continuances as well.
All right, here's the question.
Do we have a winner?
We have a winner, Kristen Knopf.
Congratulations. Here's the next one. And we're running a little out of time, so I'm going to kind of try to go quickly through a couple of these last few here. In this type of proceeding, an attorney is required to disclose all unprivileged facts needed to lead to an informed decision, even if the facts are detrimental to you winning. What type of proceeding is an attorney required to disclose all the unprivileged facts, even if it's bad? What type of proceeding? And the answer is an ex parte proceeding. Now, the rules are very, and you can join my club of being somebody that's lost ex parte TRO hearing with nobody on the other side. It's a very, very thin club, but I'm a proud member. And part of it is the disciplinary rules. Rule 3.03 indicates you have an ethical duty to disclose those to the judge, and the judge has an ethical duty to sniff them out. And so that's something to keep in mind.
We stumped the group on this one.
Ex parte, because it's Latin.
Next up, what advice can an insurance defense counsel freely give when an insured seeks advice about coverage issues? So you're hired by the insurance company to defend somebody in any type of litigation. and your client comes to you and says, well, I have a question about why this is or isn't covered, and what is it that you can, what kind of advice can you give them? The answer to this is none, or you can say you need to get independent counsel. As insurance defense counsel, you cannot provide any advice over coverage issues, what is covered, what isn't covered. So if you are in that position, you need to be very careful with what you're telling your clients when they ask those questions, and they ultimately do. You'll find at least one of those in your career if you're doing any insurance defense work.
So this is going to two, Zachary Herbert and Ashley Ramos.
Congratulations. Okay, Starbucks. Malpractice claims are 400. Can non-clients sue an attorney with whom they do not have privity? Can non-clients sue you if you ain't got a contract with them? Can we be sued by third parties? That's the question. And the answer is yes. Now, interestingly, they can't sue you for malpractice, but case laws established that they could sue you for negligent misrepresentation, and under the DTPA, they do not require privity for that. And there's a Texas Supreme Court case on there, McCamish versus F.E. Appling. And it was a deal where there was somebody the lawyer gave advice basically to somebody that was not their client. And so that ended up being a negligent misrepresentation. So there you go. Be careful.
And just on a side note, although this is malpractice, just remember that there is no privity if someone is going to file a grievance. So a non-client can file a grievance against you. It doesn't have to be the person that you are representing.
But just to make sure Kay doesn't end up with any Whataburger cards, this is going to Nicole Plagans and Phil Appenzeller.
Well, good for y'all.
Congrats.
I would have thought the answer to that was no, honestly. But, okay. Now, look, I want to take this opportunity. If you are a member, or even if you're not, but especially if you're a member, I'm going to show y'all a little bit about the website that we had redone not too long ago and what you have in there. So as you can see, the website's here. The Advocate is the quarterly publication we were talking about, where you can click on the various articles that comes out quarterly. Legal Legends is an award that's given to outstanding trial lawyers in our business over the years. And you can click on those and actually listen to the presentation that they gave. And a lot of those are really neat. Got Joe Jamel on there and just great, usually about a 1 hour, even for a CLE or something, it's good to listen to. As you go, couple of things. There's a membership directory where you can search any member. I love this. We just did this as far as the benefits go. Not only does it talk about the benefits here, but if you click, there's the state bar benefits with the actual discount codes, which are really handy to have because those are sometimes hard to find. And these are for the benefits the state bar provides that are specifically really good for litigators. There's the Vaughn line thing, which does not, again, come to Abilene. Publications, the Advocate, as we said, is just an amazing publication. You can download and look at each article. There's a great search engine to search those articles to help with your research. The News for the Bar also is a e-news that comes out every quarterly or so that has great useful articles on there. And then, of course, the grants, internships, and scholarships. If you're involved with any legal nonprofits that need some help, please look at those. And there's also online free CLE for members that already have the MCLE credits that you can listen to help you get that needed CLE. So I encourage you to look at the website. It's beyond the paywall, so you just enter your same code if you're a member as you would for your My Texas Bar page. Okay, thanks.
Hey, Kaylee, I think we're out of time, but if you could give out the CLE number again for the audience. A couple people are asking for it.
Yeah, absolutely. And, I kind of just want to thank all of y'all's time today. You know, I speak for probably most of the membership in saying that, you know, part of the litigation section was something I always had seen, but never really explored as a young attorney. And I'm grateful to now know that there is room at the table for young attorneys in the litigation section, and there's great span and reach of that section for membership. So I really just encourage, you know, DAYL membership to reach out, get involved in that litigation section, and, you know, find that niche area. So thank you all so much. Thank you, Judge Rodriguez, for monitoring, and thank you for our membership for staying through all this technical difficulties. I will give the CLE number. It's 174-116689. And I'll turn it over to you if you have any closing remarks, and we'll close it out.
We will get the emails for y'all that are the winners, and we will email you the gift card information. So thank y'all. How much fun was that? That was good. We really appreciate it. Great to see this group here, and thank you for all y'all do.
Hey, Rebecca, thank you for all your work on this, and hope to see you all young lawyers again one day live, hopefully soon. Stay safe.
And just thank y'all so much for attending. If y'all have any additional questions about the section, please feel free to let us know, or you can let the Dallas Young Lawyers know, and they'll pass that along to us. And just also on a side note on that, we also have volunteers that are not on our litigation council. So if you're looking for an area to volunteer in, we welcome as many volunteers as we can get. There's always a place for everyone. Yeah,
and writing opportunities. Who was it that said they were going to write on they had the issue about the malpractice divulging confidential information? That's a great news for the bar article. Contact the editor of that.
Let us know.
Thank y'all.
Thank you all so much.
Thank you.